If you find contract paperwork overwhelming, you're not alone. It always seems to be packed with words that many people don't understand, and there are always a lot of pages, and it's so overwhelming and so confusing. And if you're anything like me, you have probably signed a few contracts in your day that you didn't entirely understand. So this is really the reason behind me starting this video series to decode real estate paperwork. Specifically, I want to make this for my clients so that they can look at this before we start going out to see places at their own pace, in the comfort of their home, making notes and writing down the questions within the context of these contracts rather than just trying to come up with questions out of thin air. Because in the context of real estate, not understanding your paperwork in its entirety can be devastating. There are a lot of intricacies that can materially affect the transaction. And you're really signing a lot of money away. For many people, this is the biggest transaction that they'll ever make in their lifetime. So we want to make sure we're very, very careful. So without further ado, we're going to dive right in. Today is our first video, and we're going to start with the agreement of purchase and sale. By the way, if you're a returning viewer, thank you for continuing to watch my videos. If you're new here, welcome, and I hope you stay. If you like what I have to share, I'd love it if you supported me by subscribing to my channel and clicking the bell icon to be notified of any new videos that I post about Toronto real estate. My name is Mila Sheina. I'm a Toronto real estate broker, and I specialize in helping young families upsize into larger spaces to better fit their lifestyle. I've got my boots on the ground from volunteering at the Urban Land Institute to attending every event on economics, development, or infrastructure in the city that I can get my hands on. I've been on all sides of the transaction. I've been a buyer, a seller, a renter, a landlord, and I've helped countless others achieve the same result. From the thrill of victory to humbling lessons learned, I'm here to share my experience and expertise with you guys. So we're ready to dive right in. I'm going to start right off the bat with a quick disclaimer that there are a number of agreements of purchase and sale, or APS for short, that we can be talking about. But the most commonly used ones, let's say in Toronto and the GTA, are three of them. One is Agreement of Purchase and Sale Form 100, which refers to freehold properties. Freehold meaning a house, semi-detached, or a freehold townhome. In some cases, there is something called POTL, or a parcel of tied land, which is a fee that you pay when you own, let's say, a detached home, and the houses in the neighborhood have to pay for the maintenance of a road or so. In that case, you have to use Agreement of Purchase and Sale for a parcel of tied land. So that's a different form. And the third most commonly used form is the condominium Agreement of Purchase and Sale. So that could be your regular condo towers, high rise or low rise. And a lot of people seem not to know this, but some townhouses are also considered condominium. And condominium is not referring to the structure, but to the actually legal structure of management of a property. So anyways, we've got those. Today we're going to discuss Form 100, which is your freehold Agreement of Purchase and Sale. They vary ever so slightly to accommodate for the maintenance fees or the parcel of tied land fees. But other than that, they're quite similar. So let's dive right in. Here we go. We've got your Agreement of Purchase and Sale, the date, obviously, buyers and sellers' names. Due diligence must be taken to ensure that all proper owners are listed as sellers under the agreement. If it is a matrimonial home and one of the spouses is not on title, then they must sign as a consenting spouse on the agreement. Okay, so that's an important little piece. Then we've got the actual property. You have your address. You've got where it's fronting, on which side of which street. And then we've got something called more or less, the frontage of such and such, more or less, by a depth of such and such, more or less. This wording is very important because it allows for a minor discrepancy. Okay. And in the past, people have gone to court over this when there have been discrepancies of frontage and depth. And the courts will allow for a discrepancy of 3 to 5%, considering that a minor difference. Then we've got the legal description, which is another very important piece that would be very, very important. That's called easements. Easements are a right to cross or otherwise use someone else's land for a specified purpose. For our purposes in Toronto, that could be things like a fire hydrant being on your property, or power lines or phone lines going across your backyard. And an easement that's registered on a property means that you have no choice but to allow these people, the professionals, let's say Bell Professionals or Rogers or Hydro One, to come onto your property at any time of day and night to service this easement. Okay. In other cases, so somewhere where you've got cottage country, for example, and the land sizes become a lot vaster, it could be something like giving access to your neighbor to get to the waterfront, let's say, because they have no other access otherwise. And you, as an owner, when you're buying something that has an easement on it, you have no choice but to grant this easement. So you can see how this could be a very important piece to know and understand. So always make sure you're looking for those easements. And if you don't want to have a fire hydrant, or if you don't want to have bell lines going across your backyard and having bell professionals coming and servicing those lines at all hours of the day, then maybe that's not the property for you. Okay. Moving on, we've got your purchase price. We've got to put numbers and words, of course. Then we've got your deposit. Deposit is typically delivered in 3 different ways. We've got herewith, which is what you do the same day of the offer conveyance. So this is very prudent as a strategy when you're competing against other offers. Upon acceptance is the more typical one, where you deliver the deposit within 24 hours of the acceptance of this offer. And then there's something called as otherwise described in this agreement, and is the least used option. Then we've got your deposit, again, number and words. And the payment is typically, I've never seen it be payable to anybody else, but it's typically payable to the listing agent's brokerage's trust account. Okay. Now, schedules are attachments to the agreement, which we'll get to, but they cover anything that hasn't been covered already in the pre-printed sections of this agreement that we're going to go through. And sometimes if you put something in schedules that contradicts what is pre-printed in here, so for example, things like inspection, there's a clause on the agreement that says the inspection has been completed. When we add an inspection condition into our Schedule A, this overrides whatever is on the pre-printed portion. So knowing and understanding that if there's any discrepancies between Schedule A and the pre-printed portion, Schedule A always supersedes it. Okay? So that's that. Then we go into irrevocability. Irrevocability simply means the expiry of your offer. Completion date is the date that you get the keys to your new property. So that would be your closing date. Okay, typically 30 to 90 days from the day of purchase. Okay, we're flying through this. We're on to page 2, and the third clause in here is your notices. Notice clause states that an agent may be authorized to receive notice on behalf of their client if clearly indicated in this agreement. This could include the authorization by the client to include their brokerage company fax number or the agent email address for the purpose of giving or receiving notice on their behalf. Okay, so it's things like notices concerning conditions being fulfilled in the agreement, etc. Clauses 4 and 5 are very interesting, and I've made a ton of content about this because this seems to be a very dark forest of confusion for most people. Chattels included, fixtures excluded, and your rental items. What the heck does all of this mean? So chattels are anything that if you were to turn the house upside down and shook it, if it falls, it's a chattel. So it's everything that's not attached to the house. Any chattel that's in the house is deemed to not be included in the sale. So things like your couch or your TV or, I don't know, your child's toys are typically not included. So what happens with the appliances? Appliances are not typically deemed to be included, which is why we have a section here to include all the appliances. Very careful attention has to be paid to include all the appliances, okay? People go as far as putting the brand and even the serial number sometimes of the items because there have been instances where sellers in the past have replaced the appliances, their beautiful new ones, with old ones, and nobody had proof that it was otherwise before. So this is an important piece. Then you've got your fixtures. Fixtures are, if you were to shake the house upside down, those things wouldn't fall. So it's things like light fixtures, window coverings, those things are deemed to be included. So if a seller wants to specifically exclude their chandelier that they have sentimental value to, or their curtains, they have to include this in this section in this box. Okay, nothing should be assumed. So there is always a lot of confusion around this. From personal experience, a lot of sellers think that their shelves are excluded and take them with them, but they're usually included because they're attached. If you have a TV that's attached to the wall, is the TV brace included and the TV not included, or is all of it included? So specifying these things is very, very important. So when you are a seller listing your property, going through this item by item with your agent is the most prudent thing that you can do, just to make sure that there's no confusion. It is also necessary to determine whether any of the fixtures or chattels on the property, such as the furnace, water softener, or alarm system, are rental items, and if so, whether the rental contracts can be assumed by the buyer, and whether there may be any termination charges to cancel them. Rented items should also be listed in the agreement of purchase and sale and acknowledged by the buyer as excluded from the purchase price. Okay, so this is why we have the rental item section. HST. HST is not normally applicable in a typical residential sale transaction, and buyers will typically indicate that any HST payable is included in the purchase price. There may be situations where HST should be collected by a seller. For example, if more than 90% of the square footage of the home has been renovated, if part of the property is used as an operating business, such as a daycare, or as a hobby farm, or if you are purchasing a parking spot only in a condominium building from a builder. If there are any questions whether HST is applicable, sellers should be encouraged to discuss the situation with their own personal tax and legal advisors before any property is listed for sale. All right, we're on to page number 3, and we're going to start with clause 8, which is your title search. Title search is something that the lawyer performs for the buyer to make sure that the title is clear. Okay, so things that you can find in the title is the name of the legal owners of the property, and if there are any outstanding claims or liens against the property. Liens may be filed by lenders or on other financial institutions, contractors, tax collectors, and any other entity that has financial and legal claim against the property. There are also things like restrictive covenants that could be found. And restrictive covenant is an agreement or a condition that restrict, limit, or prohibit certain actions on a property or some uses of the property by the owner or tenant. A restrictive covenant can restrict anything from the height of the building to the color of the roof. Then we're moving on to future use. Future use clause basically stipulates that the seller does not make any representation or warranty about any future use of the property. The only representation and warranty that the seller makes is that the present use of the property may be lawfully continued as described in clause 8. Then we've got your title clause, clause number 10. In many ways, the title clause is the most important clause in the agreement, as it provides what the buyer will accept on or off title and what they will not accept, and whether this gives the buyer the right to cancel the agreement. This clause states that the seller will convey a clear title to the property to the buyer, save for any minor easement to utility companies, for example, and any restrictive covenant that runs with the land as long as it has been complied with. If the buyer's lawyer finds a problem with the title or with the off-title searches relating to work orders, outstanding permits that have not been closed, zoning compliance, or insurability of the property, which the seller is unable to remedy or obtain title insurance to remedy, then the buyer will have the option to either waive the problem and complete the transaction or else cancel the agreement. So listing salespeople should conduct due diligence to ensure that any title issues, including but not limited to fence line problems, encroachments, or structures onto the property from a neighboring property, or any major easements, are disclosed to any buyer in the agreement itself in order to prevent the buyer from attempting to cancel the agreement upon their later discovery. For the buyer salespeople, due diligence should be conducted as to the content of any restrictive covenant that may be registered against title, to ensure that it does not prevent the buyer from any future plans that they may have on the property, which, for example, could include an extension to the existing structure or the addition of a swimming pool. Then we've got closing arrangements. In this clause, each of the buyer and the seller authorizes their lawyers to conduct the electronic registration of the deed on closing, provided that all required documents and the closing funds have been exchanged. Documents and discharge. This clause goes on to provide that if there is a mortgage on title in favor of the financial institution or insurance company, the buyer understands that so long as they are provided with a mortgage discharge statement and the seller lawyer promise to obtain and register the discharge after closing, the discharge of this mortgage will not be registered until a reasonable time after closing. This does not apply to any private mortgage, which must be discharged on or before the closing date. Then we have the inspection clause. In this clause, the buyer acknowledges having had the opportunity to inspect the property prior to submitting the offer. As such, the buyer is deemed to accept any patent defect on the property at the time that the agreement was accepted. The clause goes on to say that the buyer has been advised to conduct a home inspection on the property and has declined to do so. So remember, this clause is included in here by default. And if you do want to have the inspection clause and you put it into your Schedule A, that Schedule A condition will supersede this clause that's pre-printed in here. Okay? Then we've got insurance. This is another very important clause, okay? Many buyers are of the opinion that if they find any problem with the property, such as the oven not working or a window broken after they sign an agreement but before closing, then they can refuse to complete the agreement. This clause makes it clear that the only way that the buyer can terminate a transaction is if there has been substantial damage to the property prior to closing. The buyer then has the choice to either accept the insurance monies for the damage and complete the agreement, or else cancel the agreement. For example, let's say there was a fire or flood before closing causing substantial damages. The buyer must make the decision whether to close or not by the closing date. In most cases, the insurance company may not yet have confirmed that they will pay for the damages caused. This is one of the reasons why in all cases, the client should be advised to seek legal advice when there is an issue as to whether substantial damage has occurred on the property after the agreement has been signed and before closing, to determine what is right for them to do. For example, in one case where this occurred on one of my lawyer's closings, they have arranged an extension so the buyer could meet with the insurance adjuster to confirm that the insurance would pay for the loss, and then the buyer was able to close. We are halfway through. You're doing so well. I know this is such an earful and a lot of information. I'm kind of mumbling on and on, but I really want to share this knowledge with you. If this is still confusing, feel free to comment underneath the video and I will make sure to go through every question and answer it to you, or you can contact me through my Instagram or my WhatsApp. All of that information is in the description for the video below. But if you're finding this information helpful and you want more videos like this, press that like button so I know that my efforts are not gone in vain, because these videos take hours to make and I do want to continue sharing more helpful info. So this would be a really helpful way for me to know that you guys are watching. All right, we're on to page 4, and this one's got a ton of pre-printed clauses. So I'm going to try to go through it as much as I can, but I do want to touch on every single one of them. All right, so Planning Act. If a land severance is required in order to complete the agreement, such as when the seller is only selling part of the land that they own, then the seller will proceed at their expense to obtain the severance. If the severance cannot be completed, then the agreement cannot be completed. This is due to the fact that without the severance, the seller does not have the legal authority to sell the land, so the agreement will be terminated. If this clause was not included in the agreement, and then it is determined that a consent for severance is necessary, the agreement would simply be null and void. Clause 16, document preparation. The seller lawyer will typically prepare the deed for the property and the rest of the closing documents, and the buyer lawyer will prepare the land transfer tax affidavit and any seller take-back mortgage if applicable. Clause 17, residency. A seller is considered to be a resident of Canada if they have been physically present in Canada for at least 183 total days in the past year. If they are residents, then no money will be held back on closing. If they are in fact non-residents, then up to 50% of the sale price would be held back on closing until the seller files their required tax information and receives a certificate from the Canada Revenue Agency that they have paid any taxes owing. Sellers are advised to seek legal and or accounting advice to ensure that they understand the consequences of having to pay any potential tax liability prior to closing, and to make sure that there is sufficient net proceeds to both close the deal, pay any mortgage, real estate commission, and legal fees, and also have enough left over for the tax holdback. Adjustments. Adjustment items can include property taxes, local improvements, common expenses, rents, mortgage interest, cost of fuel, and unmetered utility charges. The principle is that the seller is responsible for all expenses and is entitled to any rent up to the date prior to closing. The buyer is responsible for all expenses and is entitled to any rent from the date of closing forward. So this is something the lawyer does at closing date. Number 19. Property assessment. Buyers and sellers acknowledge that if there is any future property tax assessment or reassessment, which either reduces or increases the amount of any future property tax payable, then no claim will be made against either party or the brokerage companies that represent the buyer or the seller. Issues sometimes arise with newer homes when the tax reassessment has not yet been completed. The seller is still responsible for any tax reassessment for the period prior to closing. If this arises later and the seller does not pay their share, then the buyer title insurance policy will pay for this and will likely claim this from the seller in a separate proceeding. Number 20, time limits. This clause requires that all time periods must be complied with and can only be changed with a written amendment signed by the parties or by their lawyers. Case law has demonstrated that when a deposit is delivered late, even 10 minutes late, the seller has the right to terminate the agreement. Clause number 21, tender. If a transaction is in a tender situation, it means that one of the parties cannot close the agreement. In order for the innocent party to maintain an action against the defaulting party, they must be able to demonstrate that on the day of closing, they were ready and willing to complete the agreement. In order to demonstrate this, the buyer or seller's lawyer, as the case may be, will attend upon the other in person or via email to deliver proof that they have all signed documents and the closing funds to complete the agreement. Clause 22, Family Law Act. If the property is a matrimonial home and the spouse is not on title, then the spouse must sign the spousal consent section in the last page of the agreement. In this clause, the seller warns that if the spousal consent section is not being signed, then the property is not a matrimonial home. Number 23, urea formaldehyde, or UFI for short. Urea formaldehyde is a colorless chemical compound found in certain resins, glues, and bonding agents, and is most commonly associated with insulation. A controversy arose from the curing process when the product was injected into walls and other areas in residential property, and formaldehyde gas was released. A product ban appeared in 1980 because of potential health concerns after an estimated 100,000 Canadian homes were insulated, mostly between 1975 and 79, under government incentive programs for homeowners. A general consensus now minimizes urea formaldehyde as a health concern. However, the Canadian Real Estate Association has strongly urged its members to stay informed and not to treat urea formaldehyde as a finalized issue and maintain UFI reference in listing and sales documents, and more particularly the agreement of purchase and sale. Because there is no time limit expirations on this warranty, sellers should be advised that even if the buyer uncovers proof years after closing that the seller's warranty was false when given, the buyer could still bring action against the seller at the time that the problem was discovered. Number 24, legal, accounting, and environmental advice. Clients should always be advised to seek advice from experts depending on their own particular needs in any transaction. In this clause 24, it makes clear that any information provided by a brokerage to their client is not to be taken as legal, accounting, or environmental advice. Number 25, consumer reports. A seller may require a need to conduct a credit check on a buyer either prior to accepting any agreement or as a condition of entering into any agreement. This clause gives the seller the permission to conduct a credit check on a potential buyer. Number 26, agreement in writing. So the first sentence in this clause indicates that if anything added in any schedule conflicts with the pre-printed form, then the added provision prevails. For example, many agents include clause that says that the seller will discharge any mortgage, lien, or encumbrance on or before closing at their own expense. This clause should not be included as it contradicts the title clause 10 that we discussed earlier. Since the word encumbrance also includes, for example, a minor easement, this clause could give a buyer the right to cancel an agreement if they found a bell easement on title. As such, this clause should not be included in any agreement of purchase and sale. The next two statements confirm that if something was not included in the agreement, it will be difficult for a party to argue later that the term mattered to them. For example, if the listing and feature sheet stated that appliances were included and the appliances were not mentioned in the actual agreement, the seller could likely successfully argue that the appliances did not have to remain on the property after closing, and that if this was an error, it was not significant in the buyer's decision to buy the property. The lesson for all the people here is that if any item advertised in any listing is important to any buyer, it should be included in the actual agreement as well. And number 27 is kind of self-explanatory, and that basically just states that if an Ontario property is being sold, then any reference to a time or date in the agreement means Eastern Standard Time. Yay, we've come to the final page before our schedules, and that's page number 5. Clause number 28 is called successors and assigns, and this clause means that if the seller or buyer passes away, the agreement will still be binding on their respective heirs and estates. This also permits a buyer or seller to assign the agreement to a third party, yet they will still remain responsible for the completion of the agreement. Then we're going into the section that says that buyers and sellers understand that this is a binding agreement. Prior to signing any agreement, buyers and sellers should ensure that all the provisions of the agreement are carefully explained to them. This includes all the pre-printed clauses as well as any clause added to the agreement in any schedule. Clients should initial every page, which you can see on the bottom of every page. There's a requirement to initial, as well as any schedule, as well as any changes to the agreement. Now, as you can see here, there's a section for witnesses. Since the electronic signatures are available through DocuSign, there's no requirement that the agent needs to witness these signatures anymore. The security built into the DocuSign system, together with the verified email communication between the agent and the person signing, is sufficient proof that the document was signed and thus complies with basic contract principles. So here are the typical clauses and conditions that I include into my Schedule A when I represent my buyer. Starting with the buyer agrees to pay the balance of the purchase price, subject to adjustments to the seller on completion of this transaction. Pretty self-explanatory. Then I've got the two conditions in here, whichever ones are applicable. This offer is conditional upon the buyer arranging at the buyer's own expense a new mortgage satisfactory to the buyer in the buyer's sole and absolute discretion. Then we've got some wording there in regards to when that condition expires and what happens if it is or isn't fulfilled. Same thing for for offer being conditional on the inspection of the subject property with the same time requirements and restrictions. And we either remove them or cross them off if they're not applicable, depending on the situation. Then we've got the seller represents and warrants that the chattels and fixtures as included in this agreement of purchase and sale will be in good working order and free from all liens and encumbrances on completion. The parties agree that this representation warranty shall survive and not merge on completion on this transaction, but apply only to the state of the property at completion of this transaction. Nobody ever understands this clause, so I'm going to read the way that my lawyer explained it, and share that with you in just a second. A warranty is considered separate from the contract and thus is treated differently. A breach of warranty will in general give the injured party the right to sue for damages, but not the right to cancel the agreement. The most common representation and warranty given at the time of the real estate agreement is that the chattels and fixtures remaining on the property and closing will be in good working order. If this is untrue and something is not working after a buyer moves in, the buyer cannot cancel the agreement but will be able to sue for damages. This warranty is not like the 1-year warranty that you receive when you buy an electrical appliance. In contract law, there is a concept that all warranties merge, which means that they expire on closing. Since most buyers cannot check whether everything is working on the actual day of closing, most real estate salespeople change the wording of the warranty slightly to indicate that the warranty survives and does not merge on closing, but only applies to the state of the appliances on closing. A typical chattel fixture warranty found in the real estate agreement is the one that I've just described below. So what this warranty means is that if it is determined that the chattels and fixtures were not working on the completion date, then the seller can sue for them to be repaired after closing. Still, you must make sure that the home is inspected as soon as possible once the deal closes. If you wait a week, for example, and then find something is not working, the seller can just take the position that if it was working on closing and refuse to repair it. Some things cannot be checked on the closing date. For example, if you buy a home with an in-ground pool in the winter, in those situations, warranty language should be used which extends the time period of the warranty past the closing date. Okay? Again, another mouthful, but now you understand what it means to survive and not merge. Next, the seller warrants and represents that to the best of their knowledge and belief that they have never encountered or experienced any substantial water damage or extensive remediation due to leaking foundation, exterior walls, flooding in the basement, roof leaking, pest control issues including termites, or the presence of mold or any remediation of mold since they have occupied and owned this property. So this protects the buyer in the instances that there were major issues such as these. The seller warrants that all the mechanical, electrical, heating, ventilation, all their equipment on the real property shall be in good working order on completion. The parties agree that this warranty shall survive and not merge on completion of this transaction the same way. Moving on, the seller represents and warrants that during the time the seller has owned the property, the use of the property and the buildings and structures therein has not been for the sale, distribution, cultivation, propagation of harvesting of any cannabis plants with the meaning of Cannabis Act. The buyer shall have the right to visit the property prior to the completion for the purpose of inspection, for measurements, or space planning up to a maximum of 3 times at a mutually agreed upon time. Both parties acknowledge that the buyer's lender may require an on-site visit for the purpose of appraisal. In this case, such appointment requests will be accommodated to the best of abilities with as much notice as possible and shall not be counted towards the aforementioned buyer visit allowance. The seller agrees to provide access to the property for the purpose of these visits with reasonable notice. Another little piece in here, sometimes some seller's agent will remove the word inspection just to make sure that that doesn't interfere with the inspection condition. Then we have another little clause saying that the seller agrees to provide all existing keys to the buyer at the time of completion, and the seller agrees to leave the premises, including the floors, in a clean and broom swept condition. And then we have, of course, the clause that says the parties acknowledge that the information provided by a real estate salesperson or broker or real estate broker shall not be construed as legal expert advice, even though this clause has already been re-mentioned in the pre-printed clauses. So there you have it, guys. This is the entirety of the agreement of purchase and sale. It's not the only document that you sign when you are submitting an offer. There are more documents to be signed, but this is the main one. Honestly, guys, if you made it this far, you're absolute champs. And I hope now you see why I wanted to create these videos, for people to sit down and digest this information in the comfort of their home at their own pace and have their questions written down and noted, so that you're armed with knowledge at your side when it's time to prepare and sign an offer quickly. You're not stressed and signing away your life without knowing what you're signing. I'm happy and available to chat more about the agreements or talk about your buying or selling journey in real estate. The way to contact me is in the description in this video. You can click the link to WhatsApp me directly. You can book yourself directly into my calendar. You can email me at Mila@milasheina.ca.